Hello, everyone, and welcome to Introduction to Criminal Justice. Once again, I am Dr. Clay. Today's topic is the business of the court, specifically looking at the criminal trial. Now, if you recall from a previous lecture, we discussed the business of the courts during the pretrial stage. So how do we get from a crime to trial? Well, we go through the pretrial stages, right? And we learned that when a prosecutor has probable cause in one of three ways, either before or following an arrest, then we can proceed down the path towards trial. So prosecutors have the ability to issue what's called an information, right? Information is something that is almost like an emergency type pleading. And once you say, look, this is what happened, here's the facts, we can't wait for a grand jury at this moment to hear the case, judge, please arrest this person, or send an arrest warrant. That being said, if an information is issued and an arrest warrant follows, it is subject to a later indictment or preliminary hearing. Right? So indictment means it will have to go before the grand jury, or it can be a preliminary hearing. Now remember, the preliminary hearing is where only the prosecutor gets to call witnesses, but the defense has the opportunity to cross-examine witnesses. They don't have the opportunity to make statements, they'll have an opportunity to call their own witnesses, but they get to cross-examine. So defense attorneys really like preliminary hearings because they can see what the prosecution is going to call, whom they're going to call, and any weaknesses that they see within them. In addition, we can get a probable cause finding either before or following arrest with a presentment. So presentment is issued by a grand jury without a bill of indictment, right? So basically it says, yeah, there looks like enough evidence here, but we're not going to issue a true bill, a bill of indictment. And then of course, the last is indictments. These are issued by grand juries, and they are referred to as true bills. If the grand jury does not find probable cause, we refer to it as a no bill. That being said, very rarely will a grand jury not find probable cause, right? As we've said before, it's the prosecutor's playground, and quoting a famous judge from New York, a grand jury would indict a ham sandwich, right? So it's not that hard to get us over that probable cause threshold to start us down the road to trial. Now, after the arrest, the defendant at this point is brought in for an initial appearance or an arraignment. Right? So generally at this stage in the trial, the magistrate or the judge will determine bail. They'll also make some determinations as to whether they believe there's enough probable cause to hold somebody, to sustain the charges, etc. But they're really concerned about bail. Now, we discussed bail, and we talked about the significant ramifications of bail in terms of losing, in terms of prison sentences, etc. Right? So if you don't get bail, or you can't make bail, you sit in jail, you, generally speaking, get a harsher sentence, and you can't aid your attorney in defense, right? Because you don't have open access to your attorney. Attorneys can only come at certain times, and you can access them then. So ramifications of bail are huge. And that being said, we discussed that after bail, right before trial, we begin motion practice. Now, this is unbelievably important because this is where cases are won and cases are lost. So if we look at the statistics, motion practice and motions resulting in plea deals constitute about 90 to 99% of the cases. that we see in the criminal justice system. So again, 90% of the cases in the criminal justice system are going to be pled or are pled, right? So in other words, that makes trials exceedingly rare, right? Maybe 10% to 1% of all cases will get to trial. Probably even lower than that, because you have some people who will be funneled out in the system, pre-trial conversion programs and things along those lines. So we're talking percentage points, very, very small percentage points. So let's talk about the right to a speedy trial. So the Sixth Amendment guarantees the defendant the right to a, quote, speedy trial. That being said, the Sixth Amendment does not provide much guidance whatsoever, right? It says you are entitled to a speedy trial. Doesn't put a time limit, it doesn't anything. Like, it just is vague, right? And we've discussed that when something is vague, the Congress can pass laws and weigh in on it, and the Supreme Court can weigh in on it when it comes to them. So what we have now, as a result of Congress and as a result of the Supreme Court, we have two ways to measure speediness, right? So that you get your speedy trial. The first is a congressional act called the Speedy Trial Act. So if a defendant enters a plea of not guilty, a trial must commence within 70 days of the filing of the indictment or the first appearance in court. Now, we've talked in this class about how cases will go on for years. How do we get past the 70 days? We get past that via the statute, which allows for significant, what's called tolling, right? So let's say that you're the defendant and you need more time to investigate. So you file a motion for continuance, right? And you get 20 days. Well, that 20 days doesn't count towards the 70. If you file a motion with a court, any type of motion, generally speaking, that pauses the 70-day clock to a degree, right? And the idea is, well, if it takes that long to get to a motion hearing, you didn't have to file the motion, et cetera, et cetera. This is especially true when it comes to prosecutors. So prosecutors, they don't get a whole lot of tolling. If a prosecutor requests a continuance, the 70 days keeps ticking. So this is mainly focused on the defendant and the defense attorneys and their strategy. Now, most cases will go well over the 70 days. While I was working for the Coast Guard, we actually had a defendant claim a violation of the Speedy Trial Act. And we literally had to sit down with a giant desk calendar, count days that were told, et cetera, to come up with how many days this person had been held in captivity. And that's kind of how it works. You sit down with a calendar and you say, oh, that counts, that doesn't count, that counts, that doesn't count, and you respond accordingly. Now, let's say we have the Speedy Trial Act, all right, 70 days. But you can also invoke the Sixth Amendment, okay? And this is based upon reasonableness, right? So let's say you are charged with petty larceny, right, which is just a tiny, like, insignificant charge that you're going to get probation for. Let's say you don't get bail, right? So you're sitting in jail for petty larceny. You can file, and let's say it's been, 50 days. So it's not the 70 days, but let's say it's been 50 days. You can file a Sixth Amendment claim based upon reasonableness. So what factors do we look at when we determine how long somebody has been waiting for trial is reasonable? Well, the first factor we look at is the length of the delay. And so we're saying, okay, this is 50 days for petty larceny. This should just be pled out. Like, this shouldn't even be before the court. We look at the reason for the delay. Now, if the defendant is the reason for the delay, then you're probably not going to get your Sixth Amendment claim. That being said, in both the Speedy Trial Act and the Sixth Amendment, the defendant has to ascertain their rights. All right, so basically in the Speedy Trial Act and the Sixth Amendment, the defendant has the obligation to file with a court paperwork showing and claiming that it's been more than 70 days or that their Sixth Amendment rights have been violated. And the last thing we look at, especially for the Sixth Amendment, is prejudice to the defendant. Right, so did us waiting this long prejudice the defendant in any way? Now, sitting in jail for 50 days, maybe, maybe not. But what if you're sitting in jail for 50 days and you have the key witness, and that key witness is a 70-year-old lady who is going to testify that you didn't commit the larceny, she saw somebody else do it. And let's say the lady dies while you're waiting. Is that reasonable? Right? Because that creates prejudice to the defendant, absolutely. The defendant asserts their rights, then we're looking at reason for the delay and the length of the delay. But usually in Sixth Amendment, if we go above 70, right, that's Speedy Trial Act, if we go above 100, like there's no question. The case gets dismissed. Now that being said, the only remedy for a speedy trial violation is dismissal with prejudice. So what does that mean? With prejudice means the prosecutor or the grand jury or whomever cannot bring those charges again. It's dismissed with prejudice. Now this is comparing to cases that get dismissed without prejudice. If the case is dismissed without prejudice, the judge throws the case out and says, you know, you can bring it again if you want to, as long as you fix the factors or whatever was wrong with it, right? There's no remedy besides throwing a case out and saying you can't proceed with the prosecution of this person, because what can they get out of it, right? There's nothing for them besides having the weight of the criminal charges lifted off of them, right? And so that's where we see dismissal with prejudice. So let's talk about your right to a public trial. So the Sixth Amendment really deals with juries a lot. And the Sixth Amendment guarantees the defendant the right to a public trial. Now, ideally, allowing the public and including the media to witness proceedings serve as a check to keep judges honest. Okay. Does it always? No. You have judges, and this is kind of a case-by-case issue, that won't allow cameras into their courtroom. The Supreme Court doesn't allow cameras into its courtroom. It's all audio taped. But like we're talking trial courts. They might not allow video recordings. They allow as many people as they can fit under the fire code into the gallery. So that means people are dismissed. People who have significant interest in the trial, so talking victims, victim families, defendant's family, etc., they get priority. They get to sit in the first rows. And then whatever's left is open to the public. Now, theoretically, journalists are there to make sure that this person isn't getting their rights railroaded or not being trampled on, right? Because they can publish and say, look, this happened, and this happened, and this happened, and it was just wrong, it's a miscarriage of justice, etc., right? So kind of publicizing it may make it more fair. However, there is a counter argument. Public nature of trials can be damning if the defendant, especially those are tried in the court of public opinion. So let's think of Casey Anthony, right? Casey Anthony, for those of you who aren't necessarily familiar with the case, she was an attractive young lady. She had a child. One day she said the child went missing, and this was like a toddler, couldn't find her. Like the next couple of days she was out partying, like with a missing kid, she was out partying and stuff. And so they eventually charge her with the murder. They find the body, and it had been chloroformed, and a search of her computer came back how to chloroform someone. So like, if you're the defense attorney, you're sitting there going, crap, not great, right? But ultimately Casey Anthony was acquitted, found not guilty of the murders. She kind of pinned them on her father and claimed child sexual abuse and things like that. Nothing's happened to her father from it, but it was enough reasonable doubt for the jury to say not guilty. But think about how public opinion is so one-sided, right? If you ask anybody, did OJ do it? Generally speaking, there is a racial divide, but for the most part, we are all kind of in agreement that, yeah, he did it, right? Up until the point where if he hadn't written the book called If I Did It, like I could see us still having differences in terms of racial alignment on the issue of OJ, because there was undoubtedly a racist cop named Mark Furman who planted evidence, right? Which that, I mean, it is obviously terrible. I mean, good thing it ruined his career, but planted evidence to make it look like OJ did it. That being said, even with that taken into account, after OJ writes his book, If I Did It, most people say, yeah, he's guilty. Like, vast majority of people are going to say he's guilty. Black, white, Hispanic, whomever. But also, I want you to take a moment to consider public trials in terms of public opinion, considering Iranian Sharia criminal procedure. Right? Anytime we hear the word Sharia, for whatever reason, Americans freak out. Right? So Alabama tried to pass a no Sharia law bill, right, where they said that under no circumstances could Sharia law be implemented instead of Alabama. So a couple problems with that. One problem is it was a bill. So if we really wanted Sharia law in Alabama, all we have to do is pass a law saying, now we have Sharia law in Alabama. All right, so it's more for like show than anything else. What got me is when I was teaching there, I got tricked in an article, which was great. It said, under the Sharia law, in order, and this is true, in order to prove rape, you have to have 2 eyewitnesses who are not parties to the rape, right? So they're not raping parties, they're just watching. And then it said, oh, sorry, that was the law of Alabama until the 1970s. And it makes you kind of take a step back and go, damn, right? So Alabama, the one state that's so concerned about Sharia law, actually had Sharia law. And again, under Sharia law, there are good things and there are bad things. If you take my comparative class, we get into Sharia law a lot. It's an interesting study, right? Because again, it's not just somebody's legal code, but it's also someone's moral code. Now, that being said, we had the Sixth Amendment right to a public trial until the passage of the Patriot Act. Things got a little weird after that, right? Prior to the Patriot Act, the only non-public trials were those of juveniles. So juvenile trials are not, and they're still not, open to the public, right? And this includes reporters as well, which is a little scary that reporters can't be in there. But the idea is that juvenile courts are there to help the juvenile. Now, can the juvenile be sentenced to incarceration? Absolutely. Absolutely, no question. But the idea is, all right, let's get the parents involved, let's get the victim involved, let's see how we can fix this and make sure it doesn't happen again. That's the theoretical juvenile court. Really, juvenile court is basically the same as adult court. And we're just protecting them because they're under the age of 18. And generally speaking, juvenile court records are sealed, right? So after you've been found guilty or they say responsible, after you've been found responsible for the crime, all that stuff that's in your file, that the petition, witness statements, all that stuff is sealed. It's secret, right? So that's kind of where we were at. The Patriot Act comes along, and Patriot Act has created secret proceedings, detentions, and interrogations of those who threaten national security. So one of the ones that kind of comes to mind is the FISA court. So the FISA court, it's an interesting setup because nobody knows who the FISA court judge is. Nobody knows who the FISA court prosecutors are, and nobody knows who the FISA court, what's called a defense advocate, is, who they are. No clue. What we do know is that they meet in a secret location, and they go over whether or not we should be able to tap their phones for international calls. Right? It's a weird situation, right? Because again, all they're really looking at is international calling and tapping of phones, theoretically. There's other things that they've been accused of doing, which are not as noble, but we won't get into that here. That being said, the FISA court, I would argue, is actually almost more protective of the rights of would-be defendants, because in the FISA court there is a defense advocate, right? So somebody who is theoretically in your corner. When we talked about search warrants, remember, the search warrant, they keep that hidden from the defendant, or the would-be defendant, so the person doesn't destroy stuff or doesn't run, whatever. So keep that in the back of your mind, right? That FISA, yeah, it's a secret proceeding. We don't like secret proceedings. It seems contrary to the Sixth Amendment, but they do have an advocate there, so maybe it's not as horrible as we make it seem. It would be great to have media there, but then we're talking censorship. So, Article 3, and guess what? The Sixth Amendment guarantee the defendant the right to a trial by jury. Now, this applied only to the federal government. 1968. All right, so before 1968, if you were in a state, the state didn't have to give you a jury trial. Duncan v. Louisiana said, no, states, you have to give a jury trial. Now, most jurisdictions permit the defendant to elect either a bench trial or a jury trial. Bench trial, we'll talk a little bit more detail, but basically the judge makes the decision whether you're guilty or not guilty, and then makes the decision regarding your punishment. Jury trial, you have presumably 12 jurors, but there is no set number. We know the lower limit is 6, but there's no set number. We could have 55 jurors if you wanted to. They say that you're guilty, and then the judge makes a sentence. Now, that being said, there are certain cases that you want a bench trial, and we'll talk about those in a second. But, here's the big but, the court can reject your request for a bench trial without violating the Constitution. Why? Because the Constitution says you get a jury trial. So if we reject your bench trial, you're going in front of a jury. Now, bench trials are preferable for extremely complicated legal issues. So for instance, patent law and patent infringement law, those are very highly technical fields. In fact, if you want to go into patent law, you have to have an undergraduate major in a hard science, or else you can't practice patent law. It's its own bar. It's a very difficult thing to get into. It's very lucrative, but it's a very difficult thing to get into. So you want them for more complicated legal issues or extremely sensitive issues. All right. When I say that, the example I have is like a child sex offense. Most jurors, most people, when they hear somebody's been charged with child sexual abuse, automatically jump to guilty, fry him, whatever, right? A judge has seen the worst of the worst of the worst. Nothing phases judges anymore, right? After they've done it for a year or two, nothing phases them. So they can get into the issues and be sensitive of these sensitive issues and make theoretically a fair and impartial decision. Now, on the flip side, jury trials are preferable for simple, non-inflammatory issues, right? Such as the possession of marijuana, or with an extreme sympathetic defendant, like a 19-year-old. So I remember, I'll never get called for jury duty, but my mother was called for jury duty when I was a kid, and they're not supposed to tell you like what the case is about, but she told me because I was a kid, who the hell's going to listen to me? The kid had rented a boat from Marina. I grew up near the Lake of the Ozarks. If you've ever seen the movie Ozark, that's my home. Anyway, he rented a boat at Lake of the Ozarks and had friends aboard. They get stopped by the water patrol, and lo and behold, they search the boat and they find marijuana, right? And immediately the kid who rents the boat with the marijuana says like, no, that's not mine. I don't know whose that is, et cetera, et cetera. And of course, the police don't believe him because the jury, the boat's in his name, and that's not mine is not a new thing that police officers hear. So he went to trial, right, for possession of marijuana. Think about how much time and money that cost. He was also 19, if I recall correctly. So he was also very sympathetic. Ultimately, the jurors, including my mother, voted not guilty, right? Because they were almost outraged that the prosecutors brought this case to trial. Possession of marijuana and 19-year-old, really, you bringing this to trial? Like, they were angry at the prosecutor. And so that's a risk you do run being a prosecutor. Now, other extremely sympathetic defendants I've seen in the past, people who are dying. So it will get brought out that so-and-so has this disorder and they only have so long to live. People who are in wheelchairs, especially if the paralysis is the full body paralysis as opposed to just the legs. You're going to get the sympathy of the jury, right? You just are. Especially if, let's say you have, and this has happened before a lot, you have a cancer patient who has cancer, their hair is falling out, like they look like they have cancer because they're skinny and whatnot. For those of you who don't know, chemotherapy, one of the main drugs that they use is the same drug in rat poison. So you can guess what that looks like. And my mother had it, and she passed my junior year of high school, my first day. That's not here or there. But if you have somebody who goes into court because they have cancer and they got busted with marijuana, you are going to piss off the jury so much that they might take a swing at you. right? Because we talk about marijuana, marijuana actually has benefits, right? So when we're talking about, especially the treatment of cancer, cancer makes you not want to eat, right? Marijuana does. Cancer and chemotherapy makes you throw up repeatedly. Marijuana stops your gag reflex. Right? Other benefits, marijuana makes you feel good. Chemotherapy, literally, you feel like your body is on fire. So you get up in trial and you say all of that to a jury, and the prosecutor gets up and goes, yeah, but at the end of the day, they still had marijuana. That jury is not going to convict. And that jury is going to make sure that you are voted out of office. You can be surprised how pissed off juries can get at different lawyers. Like they get vindictive. That being said, as noted before, there is no right to, or there is a right to a trial before jury, but not to a bench trial. And if we're talking a marijuana case, especially a cancer patient or a kid, I want a jury trial, right? Because if the guy is 18, right, so he's just above the threshold to go to juvenile court and did something stupid, maybe vandalized or something like that, the jury is just going to be, they're just going to be like, this is stupid. Like, he's a kid. Like, things happen. Especially if the vandalism's already been taken care of and stuff like that, the jury's not going to find the person. I mean, they might, but for my best insight, I would say they wouldn't. So that leads us, right? We know we have a right to a jury trial, not a bench trial. That leads us to jury selection. So jury selection can be very complicated. But first, I have a personal observation. Jurors are generally very, very, very stupid. They are basically meat with eyes. Because it's extremely easy to get out of jury duty. And you would think, like, jury duty, oh, this is going to be a fun court. No, jury duty is the most boring thing you can do on the planet. So we already know that the people who are serving on the juries, and when we select juries, we'll talk about this in a little bit, we don't want smart people on our jury. Right? That's from the prosecution and from a defense standpoint. We don't want smart people because they can think critically through the facts, they can organize, they can articulate, etc. We want people who will base their entire decision on emotion. Right? Especially you have like Casey Anthony, where she's accused of killing her child, and we blow up the picture of her child, like, you know, almost 2 stories tall so the jurors can see her. One, that shouldn't have happened. And 2, we're trying to get the jury angry, we're trying to get the jury upset instead of letting the jury think through the facts. So how do we decide who gets to become a juror? Well, we start with what's called the master list. Master list of its eligible jurors. Generally speaking, it's based upon voter registration and DMV records. Now, there are some taxation records that can be based on things like that, but the big 2 are voter registration and DMV. So theoretically, if you did not register to vote and you don't have any DMV record, like you don't have a license or a non-ID or something like that, you'll never be called for jury duty. Now, you might think, oh, that's not, like, that doesn't happen. Well, consider something like New York City. How many people in New York City have cars? Like, quite a few. But do most people? No. They have subways, right? They have all these other ways to get around. So it can be limiting in terms of our pool. So that being said, when we have a master list, the clerk has to go through and find the eligible jurors, right? So to be an eligible juror, you must be at least 18 years of age. You have to reside in the jurisdiction, and you cannot be a felon. Most people regret or just hate the fact that they are going to get called for jury duty. Like, you get the summons, and it's literally a summons, not a very fun thing to do. However, if you are bored in New York, you may actually volunteer to be on a jury. I'll say that again. In New York, you may volunteer to be on a jury. So if you want to know how, go into the slide, click this link. It will take you to the state government pages where you can fill out a volunteer sheet. Now, generally speaking, from the master list, we pull the jury pool, also called veneer, right? And it's selected, theoretically supposed to be selected randomly, and most times it is, from the master list, right? So you have like 10,000 names on the master list, and you think, well, this is kind of contentious. Let's have 40 jurors, right? That's the veneer. So you have 40 jurors show up, right? And your jurisdiction, you're only going to go to 12 jurors. So you have the jury veneer, and from the veneer, a pool of jurors is randomly selected for voir dire. Right? Voir dire is the process of examining jury panels for impartiality. Right? So this is the jurors get to come sit up front, sit in the jury box, and then they get questioned either by the judge or who has questions that the prosecutor and defense have submitted, or they get questioned by the prosecutor and defense attorneys. They try to be friendly. They try to come off in a good light because they are the same people who are going to judge whether you win or lose. But you ask jurors, simple questions, everything from what's your occupation to how far did you go in school, what's your education like, et cetera, et cetera, et cetera. Now, the reason we do this is theoretically, yes, we want impartial jurors, all right? So we have two tools at our disposal. We have challenges for cause, which are unlimited, and we have preemptory challenges, which are limited, and the number depends upon the type of case. So murders usually get more preemptory challenges than like shoplifting, right? So as we're questioning jurors, we get to a juror and we say, do you know anybody in this case? And the juror says, yeah, the defendant's my cousin. Immediately, that prosecutor's going to turn around and say challenge for cause, right? And that person will be dismissed. They're not in trouble or anything. It's just, oh, whoops, we accidentally got you. You're dismissed. And you still get, I think in New York, it's $50 a day to be on a jury. So it's not great, but you can't be fired from your job. They have to leave it open for you. So yeah, that's a challenge for cause, right? Or somebody says like, let's go down the race route, right? You have a black defendant and you have somebody who's unbelievably racist. And they get up there and you ask them a question like, oh, have you formed any opinions about this case yet? Yeah, black, I know their type. Guess what? We're challenging that person for cause. I mean, it's like, just no, that's ridiculous. Because the whole point is to get a theoretically impartial jury. Now, if we just had challenges for cause, that would be great for finding an impartial jury. But we have the preemptory challenges. For preemptory challenges, we do not have to give a reason. All we have to do is say preemptory challenge, and you get a certain number of them, and then that person is gone. They're excused from the jury, the veneer. They're done. Again, not in trouble or anything like that. It's just how juror psychology works. If you've ever seen the show Runaway Jury, it's about jury consultants, and like it's a really kind of intense thriller. It's a good show. It's a good movie. It's about jury consultants, and there are people who make very good livings, based on helping people pick jurors. Right. So one of the cases I observed when I was in Rhode Island, the cult case that I think I've talked about before, they were picking the jurors, and one of the jurors was a PhD in biochemistry. And immediately, both sides at the same time said preemptory challenge. Well, there's a problem there for the judge, because who said it first? Who do I assign this to? Usually you're going to assign it to the prosecutor at the same time. But they didn't want a smart person on their jury. Right? They wanted people who didn't graduate high school. Because theoretically, they're going to come from a place of emotion, whereas somebody who's intelligent, who has gone through the rigmarole, is going to make decisions based upon logic and reasoning. Now, that being said, there is one time that you can inquire as to a preemptory challenge. Now, this only occurs when it's the prosecution. All right, so let's say a prosecution, you notice that they are using their preemptory challenge. You have a black defendant, or maybe white defendant, doesn't matter. But you see that they are using their preemptory challenges to get rid of all of the black jurors. At that point, you can raise an objection. And what happens is we employ what's called the Batson test. And the prosecution has to go juror by juror and explain why, give a good reason why they were removed from the panel. They can't do that, all sorts of bad things happen. All right? So just know that preemptory challenges allow us, theoretically, it's supposed to be like you can't reach cause, you come close. No, it allows us to shape a jury in the way we want and not impartially. So here's just a graphic for how jury selection looks like, right? So let's say that you have a jury pool, right? Of 100 to 1,000 citizens, more for depending on circumstances, and they're summoned for a 2 to 4 week period to serve on a jury, right? And from that, we kind of pull our jury panel. So we select 30 people. And if the case is dismissed, those 30 people go back into the jury pool. If the case continues, we go through voir dire. Then, if we go through voir dire, there will be 16 persons who are challenged or they're not used, and they will return to the jury pool. So we can pull them back out. It's 2 to 4 week service. Pull them back out. We will have 14 selected jurors. And I'm going, what, 14? Are you sure? Yes. Because what it's going to result in is a 12-person jury and 2 alternates. Now, the 2 alternates are treated like jurors, except they're kept away from the jury and really anyone else, but they can take notes and things like that. The idea is if a juror becomes compromised, a juror gets sick, something happens, this alternate juror has seen the whole trial and can fill in, right? So we usually have 2. Then once we have our 12-person jury, if it doesn't get settled, they get returned to the jury pool. We go to trial, verdict, and then we return them to the jury pool. Right, so you can be selected again. It's random, but that's the way it occurs, right? That's kind of our paths to how we get to and from the jury pool. Now, let's talk about how trials actually play out. So in criminal trials, it begins with an opening statement. The prosecution, since they bear the burden of proof, begins, and they are limited to referring to what's called admissible evidence. So evidence they know is going to be able to be admitted. If they refer to something that can't be admitted or won't be admitted, an objection can occur. Now, opening statements are not like TV. No arguments occur here. Basically, what you're doing is you're introducing the parties to the jury. You're introducing the case to the jury. Right? And the idea is so that way they don't have, so that way they have orientation, right? So that way they don't have any clue who the hell this person is and why are they talking to me. You've told me, right? You can make a comment here and there. You probably won't get caught. That's kind of argumentative, but generally speaking, it should be a direct path to this is what you're going to hear. This is what they're probably going to say. You're going to see this evidence, and at the end, we're going to ask you to conclude guilty. There you go. So prosecution goes first, defendant goes second. Right? And defendant can address really any issues that were raised in the opening. And then once the defendant is done, we open what's called the state's case in chief. Right? So the case in chief is where the state or the federal government puts on their evidence. Right? And generally speaking, we require it to be competent, material, and relevant. Right? So the evidence they present has to be competent, material, and relevant. And we'll talk about the different types of testimony in a second. Now, the problem that we see is what's called the CSI effect. And we've seen this ever since that show CSI came out, and now all the cop shows have CSI, right? Every juror, for whatever friggin' reason, wants blood stains, wants semen, wants DNA, etc. Like, it could literally just be the guy robbed the gas station and the jurors want semen. You know, like, that doesn't happen. Yeah, so jurors, they're complicated people. That being said, the types of evidence, there's four really main types. The first is real evidence, and this refers to physical objects. So for instance, the murder weapon, that's real evidence. There's testimonial evidence, which is a sworn verbal statement by a witness. So this is where we talk about the cross-examining and questioning of the witness. It has the theoretically same effect as real evidence, right? There really should be no different treatment between them. Then we have direct witness, direct evidence. This is an eyewitness and testimony and evidence that the defendant committed the crime. Now, they will be asked questions, and then they'll be cross-examined and all that lovely jazz. This should be treated just like real evidence and just like testimonial evidence. And then what you're probably going to have most of the time, most of the time you're not going to have real evidence, testimonial evidence, direct evidence. Most of the time, you're going to have circumstantial evidence. Circumstantial evidence is just evidence from which a fact can be inferred. Now, unlike TV, I'll tell you this. Most cases are circumstantial. Just because a case is circumstantial doesn't mean it's not a good case. Because you see that all the time in like CSI or NCIS or something along those lines. Like, oh, this case is completely circumstantial. Yeah, most of them are. Right? You have a set of facts and you can infer things from those facts. So this evidence, real evidence, testimonial evidence, direct evidence, circumstantial evidence, is articulated through a series of direct and cross-examinations. So when you call a witness to the stand and you ask them questions, you engage in a process of direct examination. And you are limited to the questions who, how, what, when, where, and why. So you cannot lead the witness. Now, once you're done questioning your witness, the defense can get up and cross-examine your witness. On cross-examination, they can lead. What I mean by leading is, think about it this way. For direct examination, you can say, where was the party? And the answer is 127 Sanchez Street, right? Cross-examination is, wasn't the party at 127 Sanchez Street? You can see where there's a big difference, right? One is open-ended, the other basically states a fact, and the only purpose of the witness is to agree with them. Now, direct examinations, you're going to try to build up your witness. Cross-examinations, we're going to try to tear down your witness, right? Accuse them of lying or show that they're lying, things like that, or they're misremembering or whatever. That being said, during this process, you have to be very careful and mindful of the jury. So direct examination, you have to understand the jury has needs. They need to know certain things. You've been living with this case forever, right? Like, so you understand like what's going on in the case. They don't. They need to know from the very basics all the way up to what you know. Now, in cross-examination, you have to remember the same thing. The jurors have needs, but the jurors are also people. Right, and so let's say you have a 16-year-old kid who was who gave testimonial evidence, and you get up there and you tear into that kid. That jury is going to hate you. Or that jury is going to say, like, I'm not listening to anything they say. You know, guilty, I don't care. That was just inappropriate. So you have to change your tone of your voice. You have to change your demeanor based upon the direct examination and cross-examination and the needs of the jury. So, after we have the prosecution's case in chief, right? They say, like you hear on TV, the prosecution rests. Then the defense gets a chance, right? So, generally speaking, what's going to happen is after the prosecution's case in chief, they said they rest, the defendant is going to file a motion to dismiss. And what's it going to say is the prosecutor failed to establish a clear case of guilt. Now, this will generally always be denied. It's just something that we do because it's malpractice if we don't do it, but it could work, right? So after that gets denied, the defense counsel, presents evidence and engages in direct and cross-examination just like the prosecutor. But the roles flip. Because now the witness you're calling is for the defense. So you can only ask who, what, when, where, and why. You're on direct. The prosecution can cross. They can lead, right? You are at 127 Sanchez Street, right? Right, they can lead. So the roles get reversed a little bit. Now, that being said, once the defense rests, right? They have no more witnesses or anything along those lines. There is a potential, although it very rarely, if ever, happens, for a rebuttal and a surrebuttal. So the prosecution is given the chance to introduce new witnesses or evidence in effort to refute the defense's case. All right, so if something comes out in the defense's case and it's like blatantly untrue and they weren't prepared for it, they can offer a rebuttal and say, well, you know, this is proof that they're talking about is untrue. However, if they get a rebuttal, the defense is guaranteed and granted the right to a surrebuttal, in which they may rebut the prosecution's rebuttal. So they can't, we're not talking about the case in chief anymore. We're not talking about the case. We're talking about, prosecutor says, oh, there was just one issue, and then the defense says, nope, that issue doesn't matter, and we just argue back and forth about the little issue, not guilt in and of itself. So once we have, again, the plaintiff's case in chief and the defendant's case in chief, very rarely will we have rebuttals or surrebuttals. Then we move into closing arguments. Now, these are arguments, right? So what they do is they're a summation that allows the attorney to argue the evidence presented, right? And say what it means. So that being said, the defense usually goes first, then the prosecutor, and then the defense is entitled to a rebuttal. And that's usually about as far as it goes. All right, so the defense says, well, you heard this, and you didn't see the bloody glove here, and that means this, and this means this, and this means that's argumentation. And if you're a good lawyer, you can sound just as confident and eloquent as possible. Then the prosecutor will do the exact same thing, but they'll argue a little bit against what the defense counsel had just said. And then defense, if needed, will present a rebuttal and say, well, the prosecutor just told you this, this, and this, but reality, this, and this. So the rebuttal, so defense usually gets the last word in. If they choose the rebuttal. If they don't choose to rebut, then it's usually the prosecution. At the end of closing arguments, before the jury is, well, it depends, before or after the jury is dismissed, the defense attorney will file what's called a motion for a directed verdict. And what this means is, judge, they don't have enough for a guilty verdict, right? Based upon their evidence and based upon our evidence. There's not enough reason here to believe there's a guilty verdict. So you should send the jury into jury chambers with the instructions that they return with a not guilty verdict. Which I know that sounds really weird, but like it does happen occasionally. Like if a motion for directed verdict happens, the judge says to the jury, you must return with a verdict of not guilty. And so the jury just kind of like walks into the room, turns around, comes back, says not guilty. It's the weirdest thing. But most of the time, it's going to be denied, right? Because there's always appeals and there's other issues that we get into. So usually it's going to be denied. Then, after that gets denied, then we begin the charging of the jury. So the judge informs the jury of the law, their duties, and the issues raised at trial. This is very long and very, very boring, because the judge is literally reading statutes. After we charge the jury is dismissed to a secluded room for deliberation. Right? So basically what usually happens is the jury retires to this room, and the jury foreperson, whether they're elected, appointed, however, calls for an initial vote. Now, that being said, most states require a unanimous verdict, a unanimous vote of either guilt or innocence. It has to be completely unanimous, and that's most states. Some don't, and we get into that in criminal law 1 and 2. So, what happens if they vote and they disagree? Well, then they deliberate and they try to convince each other and sway each other, etc. So they vote again and they still disagree. And now the sides are entrenched. Like no side is going to go for the other side. Like half think he's guilty, half think he's not guilty, or 11 think he's guilty and 1 thinks he's not guilty. What happens at this point is what's called a hung jury. All right, so the jury deliberations fail to generate a unanimous verdict of guilt or innocence. The case is dismissed in open court. The judge declares what's called a mistrial. Now, the prosecution can retry the case or just drop the charges. If they retry a case, it is not a violation of double jeopardy. Because you're talking a brand new set of, and it's the same case, you're talking a brand new set of jurors, etc. Now, that being said, if a jury comes back as a hung jury, depending on the circumstances, the prosecution might not proceed with more charges, right? Because like it takes a lot of time and a lot of money. They've already kind of lost. It is what it is. But if we're talking like a murder trial, well, then in that case, that's probably different. That being said, when we look at the statistics, only 6% of criminal trials end with a hung jury. So that means 94% of that 1% will come back with a guilty verdict or a not guilty verdict. More often than not, it's a guilty verdict. So, what happens? The verdict and judgment get announced, right? So the jury comes back into the courtroom and announces its decision. Now, there's something called jury nullification. If you ever want to go into a courthouse and scream the word jury nullification or pass out pamphlets about jury nullification, you will probably get every case in that courthouse dismissed. They'll get a new jury, but you'll have them dismissed. So jury nullification is this idea that they can nullify or suspend force of strict legal procedure, right? So what does this mean? It means the jury has the power to nullify, but doesn't necessarily have the right to. So what this basically means is the jurors could get into the jury deliberations, right, into the deliberation room. And let's say it's a simple possession charge of marijuana. They get into the deliberation room, and everyone's like, yeah, he did it, he had it, but it's pot, come on. Right, like it's freaking ridiculous. We're gonna send a kid to prison for this. And so the jury can come back and say, not guilty. Even though they believe he's guilty, they can say he's not guilty. There's no cameras inside the jury room. There's nobody's allowed inside. The only person who can come close is the bailiff, and the bailiff just brings messages or brings physical evidence that the jury requests, but they can't enter the room. Right, so we never know if a jury is nullified. But if it's like a pot case like that, you can usually tell that they're like, okay, this is stupid, not guilty, even though they know he has it. Now, some states are taking steps to prevent jury nullification. So even the mention of it in a courthouse can result in a mistrial. All right, and usually it will result in a mistrial for every juried proceeding in the courthouse. Now, assuming that doesn't occur and we get a verdict and a judgment, the prosecution or defense may request jurors to be polled to determine whether any juror has been pressed into voting a certain way. All right, so we go down the list of the 12 jurors and I say, what is your verdict? Did you feel any undue pressure, distress, blah, 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 blah. Next person, what was your verdict? All right, and this gives an opportunity for somebody who's been bullied into it to say, I don't really agree with this. And as soon as that happens, a mistrial is declared. Like, it's done, it is over. So, because we don't want people being pressured. Then, as soon as we poll the jury, if they find a guilty, the defendant will file 3 things in court immediately. The first thing that they're going to file is a motion for a judgment notwithstanding the verdict. What this basically means is, judge, let's be reasonable, look at all the evidence. No reasonable jury could have found my client guilty, they're unreasonable, take away their verdict and substitute it for a not guilty verdict, which the judge has the power to do. Do they do it? Very rarely. Then you'll file a motion for a new trial. And you basically tell the judge, I didn't get a fair trial, and here's why. And usually that's denied. Then if that gets denied, you file immediately a notice of appeal. And you give this to the prosecutor and you give this to the judge saying, hey, we're appealing. Here are some of the issues. We'll update you on the other issues, but because you have like 30 days to file it. But here are the things that we are appealing, the grounds for our appeals. Right? And so that puts the court on notice, that puts prosecution on notice, and you buy yourself time. So next class, we are going to look at the post-trial proceedings of courts, specifically sentencing and appeal. Thank you so much for listening. And again, if you ever have any questions, please do not hesitate to reach out to me.